Good evening and welcome to the special meeting of the Santa Monica Rent Control Board this Thursday, April 9th, 2020, which is being conducted via video and teleconference pursuant to Executive Order N-2920 issued by Governor Newsom. In an effort to reduce the risk of spreading coronavirus, members of the Rent Control Board and Rent Control Board staff will participate via video conference. This meeting will be broadcast on City TV Channel 16 and streaming on the city's website as normal, but participants may also join via teleconference per the methods listed in the notice. May we have a roll call, please?
Commissioner Salton.
Here.
Commissioner Foster.
Here.
Commissioner Duran.
Here.
Commissioner Trosis.
Here.
And Chair Phyllis.
Here.
All members are present.
The next item on the agenda is item number 5, approval of the minutes from the February 13th, 2020 meeting of the Santa Monica Rent Control Board. Is there a motion?
I move to approve the minutes.
I've also reviewed and I will second.
Motion made by Commissioner Trosis, second by Commissioner Foster. This is just a voice vote, or do we have to do everything by roll call vote because it's video conference, Lonnie?
Correct. That's correct.
Okay, so can we do a roll call vote, please?
Yes. Commissioner Trosis.
Yes.
Commissioner Duran.
Yes.
Commissioner Salton.
Yes.
Commissioner Foster.
Yes.
And Chair Phyllis.
Yes.
Motion carries.
Next item on the agenda is special agenda items and announcements pertaining to the Rent Control Board. Do we have any announcements for this evening?
Yes, I have a few announcements I'd like to make, or give you a little bit of background on what's happened since our last board meeting was canceled. So good evening, commissioners and members of the public who have joined us. Thank you for joining us for our first teleconference meeting. The 4 days following the cancellation of the last board meeting were a whirlwind. That Friday, we got direction from the city that half of our staff should begin working at home as of Monday, April 16th. Over the weekend, that changed quickly, and everybody was advised to telework as much as possible. Thankfully, due to the forward planning of the city's information systems department, all of our staff members have been able to have access to all of the tools that we use, including our rent database, our document management system, and our documents on the file servers. So without missing a beat, the agency pivoted to providing all of our services virtually via phone, email, and everyone's new friend, the teleconference and video conference tools. Our information coordinators and analysts are answering questions by phone and email every day. Anyone looking for answers to their rent control questions should call us at our regular number, 310-458-8751, or email us at rentcontrol@smgov.net. Also, we've been holding our hearings and mediations. We've kept them on calendar and conducted them either by teleconference or video conference. The hearing officers made the necessary adjustments, and it's working well. And I wanted to share with you a comment from a participant in one of this morning's hearings. He said, "I have nothing but positive things to say. To be able to do this remotely was tremendous. With technology, it was easy to have all of the evidence available electronically, top marks for the telephone hearing." So I was very pleased to see that and thankful to our hearings manager, Lynn Nalaboff, for helping facilitate that. And of course, the board secretary, Lonnie, has helped with that, and Lima Noseworthy as well. I'm very proud of the way our staff was able to pivot and adjust to this rapidly changing situation and to continue to provide the vital services that we offer. The other very important information I wanted to share with the community that we serve is the City Council's emergency order in March limiting evictions in response to the economic impacts of the coronavirus pandemic. A revised order was issued yesterday strengthening the temporary moratorium on evictions. The original order protects renters from eviction if they prove with documentation that they cannot pay rent because they've been financially impacted by COVID-19. To do so, within 30 days of the rent due date, tenants must notify their landlord in writing of their inability to pay rent due to COVID-19 and its impacts and provide supporting documentation. A form that tenants can use to provide the required notice is available on the board's website at smgov.net/rent-control and on the city's COVID-19 information page at santamonica.gov/coronavirus. The order requires that tenants repay all deferred rent within 6 months after the crisis is over. The initial moratorium was later broadened to protect businesses and to prohibit Ellis Act evictions during the emergency. The revised supplemental order issued yesterday extends the end date of the moratorium to May 31st, and that could again be extended in the future. The new order also requires that beginning April 24th, landlords must provide tenants with notice of the eviction moratorium either by posting notice at their property or mailing or emailing notice to tenants. Landlords must include a notice of the moratorium when serving tenants with any notice to pay rent or quit or other notices given to tenants as part of the eviction process. Under the new order, all no-fault evictions are prohibited. Previously, only renters impacted by COVID-19 were protected from no-fault evictions. Landlords may not evict tenants who have unauthorized occupants or pets in their homes. Additionally, tenants may refuse to let their landlord enter their unit unless the landlord needs to remedy a dangerous situation that impairs the health or safety of the tenant or other people, or threatens to cause substantial damage to the unit. If an owner or representative enters a unit, they must observe social distancing, wear a face covering, and properly sanitize any area they enter before leaving the unit. Finally, the fine landlords face for violating the city's tenant harassment laws has been increased from $10,000 to $15,000 during the emergency. People with questions may contact our office at 310-458-8751 or email us at rentcontrol@smgov.net or contact the Public Rights Division of the City Attorney's Office at 310-458-8336 or consumer.mailbox@smgov.net. And that's the announcement I had for this evening.
Thank you. Looks like we have one commissioner in the queue, Commissioner Foster.
Thank you. Thank you, Tracy, for that. How are we contacting all of our landlords in Santa Monica and letting them know that they have to do this within the next 15 days? How are we contacting them?
We will not be contacting them. We are working on a newsletter that will go out in May, but the contact will be made by the City Attorney's Office. I think it's primarily through the press, through the announcements that the city's making available daily. I can get, while you're meeting, I'll get the information and provide that for you, that people can sign up to receive daily announcements. But the notices would be provided by the City Attorney's Office or the city.
Thank you.
I see Commissioner Torosis in the queue. Commissioner Torosis.
Great. Thank you, Chair Phyllis, and thank you very much, Tracy, for that comprehensive update. I'm just wondering, obviously, you know, we are not going back to normal, quote unquote, in an expeditious fashion. And I want to ensure that we are providing as much information to our rent-controlled tenants and landlords as possible, similar to what Commissioner Foster said. Are providing technical assistance and exactly what can and cannot be asked for, especially as these stimulus bills come down? I've been hearing reports of landlords demanding repayment with certain bills that are, checks that will be issued. And even if not, like, are we there to help assist in a repayment plan to make sure that it's equitable and makes sense for both the landlord and the tenant?
I'm sorry, you cut out there for a moment, but we are helping provide information through our website. We're continually updating our website with new information as it's becoming available and links to the forms. The city attorney's office developed a form that tenants can use to notify their landlords of their inability to pay rent, and it includes instructions on the type of documentation that should be provided. So we can informally help people talk through things. Certainly our information coordinators can do that. Tenants should know that they are not obligated to sign any type of repayment plan. The order itself requires that tenants repay the rent or the deferred rent within 6 months, but nobody's required to enter into a written agreement in order to preserve that right. They have that right as given by the order. Do you want to add anything, Mr. Lewis?
Well, Tracy, could you clarify? It's not 6 months from today. It's 6 months from the end of the crisis.
Yes, thank you. It is 6 months from the end of the emergency order. That's correct.
Thank you. That's exactly the type of information I wanted to just make sure we got out there. And then also say, informally, if people have questions, they can come to the rent control board. And obviously, again, repayment plans and installation payments are always a possibility.
Yes.
Okay, next item on the agenda is item 10A1 and 10A2, both of which are petitions for owner occupancy exemptions. I will entertain a motion because these both seem relatively straightforward to grant, unless there is a request for a staff report.
I was going to move to at least grant 10A1, if not both.
Do you want a staff report on 2, Anastasia?
No,
Okay.
It's just that 2 had a teeny tiny procedural issue, but it's not significant.
Okay, so is there a motion to grant
10A1 and 10A2 to accept the staff's recommendation to grant both exemptions?
I'll second.
Can I just,
Okay, so
before we do that, can I ask a question? I just wanted to ensure, and maybe I missed it. I had one question about 10A2 that I just wanted to address, and then if it gets addressed, I'm happy to move that motion. On 10A2, does Mr. Ismanto have any ownership interest in any other properties in either California or anywhere else? Did we have any record of that? Because I was just unclear as to why the tenant would dispute his claimed occupancy, and I wanted to know whether or not there was another place he could have been living if that was in dispute. I didn't see that there was one, but then I also didn't see that it was clearly stated out that this was the only place that he had any sort of ownership interest.
Sure, Commissioners, this is Hakomanish Mordezai. The tenant disputed because the email that they sent to staff that he didn't, that Mr. Ismanto didn't actually live on the property and that he never saw him except once a week. And so recommendation sets out the evidence, the tenant never actually appeared to provide testimony on that. So that was the only thing that we got. There is no other record property that Mr. Ismanto has in this case.
Okay, I'm prepared to second Commissioner Foster's motion. Thank you.
Okay, so we have a motion by Commissioner Foster, a second by Commissioner Terosis.
Just to
There's no one-
clarify, I think I heard Commissioner Duran second it initially.
Yeah, that's right.
Oh, sorry, Commissioner Duran. So we have a motion by Commissioner Foster and a second by Commissioner Duran. Can we have a roll call vote?
Commissioner Duran,
Yes.
Commissioner Salton,
Yes.
Commissioner Foster,
Yes.
Commissioner Terosis,
Yes.
and Commissioner Phyllis.
Yes.
Motion carries.
Okay, next item on the agenda is item 10B1, appeal of a dismissal of exemption application for 1322 Ocean Park Boulevard, applicants S. Ziegenhorn and W. Ziegenhorn. May we have a staff report, please?
Commissioners Sarah and Will Ziegenhorn hold a 50% ownership interest in this property, which is 1322 Ocean Park Boulevard. They're exempted as an owner-occupied property of 3 or fewer units. The record supports their claim that they live on the property and that the property only has 3 units. The Rent Control Agency, however, dismissed their application because neither spouse has a 50% individual ownership interest, which is required for the exemption under the Santa Monica Charter and the board's regulations. The Ziegenhorns have appealed that dismissal. They claim that because the community formed by their marriage has a 50% ownership interest, so do they as individual spouses, so long as they are married under California law. California's family law code states that under Section 751, that when a property is owned as a community property by a married couple, the respective interests of each spouse are equal. The family code clarifies further under Section 1101A that when one living spouse brings an action for breach of fiduciary duty as to a community asset against the other spouse during their marriage, the plaintiff spouse can only claim impairment of a 1/2 interest in the community asset. California statutory law, therefore, recognizes an individual spouse's claim to a community asset as 50% ownership of that asset. Case law also adheres to this principle. When a spouse died and there was a dispute about community property funds that the decedent spouse had deposited into a separate account as trustee for a third person, the court held the surviving spouse was only entitled to 1/2 of the community property funds by operation of law. The court said, quote, because each community property asset is only half his or hers to give, the spouse cannot dispute of more than that 1/2. But courts have not only adhered to this principle after the community has been terminated by death or divorce, but also during marriage. A California businessman owned a 50% ownership interest in a business as his separate property. He transmuted that asset into community property by conveying it in a deed to his wife as a community property interest. The question then arose in the context of a tax dispute as to how much of an ownership interest the wife had in the community asset. Under the reasoning urged by the Ziegenhorns, the court should have found that a wife had full ownership over that asset, the asset being a 50% ownership interest in a business. But the court ruled that the transfer constituted under both California and applicable federal laws a valid completed gift from the husband to the wife of a 25% ownership interest in the business. Since the couple had a 50% ownership, what the courts recognized for the wife was half of that, which is a 25% ownership interest in the business. Here too, in this case before you, the community property is a 50% ownership interest, this time in the real property at 1322 Ocean Park Boulevard. Because all statutory and case law provide that each spouse only holds a half interest in whatever asset the community owns, Mr. and Mrs. Ziegenhorn can only claim to individually have an ownership interest of 25% in this property, making them ineligible for the exemption under the rent control law. In their written response, The Ziegenhorns also suggest, without naming actual cases, that the board has previously granted an owner occupancy exemption to a married couple who only hold a 50% ownership interest as the community. They suggest, therefore, that dismissing their application on this basis is a denial to their right to equal protection under the law. First, staff is not aware of any previous case in which the board has considered whether to grant an owner occupancy exemption to a couple who only own a half interest in a rent control property. Second, like all administrative decisions that are not published, the board's administrative decisions are not precedential. And finally, even if the board had in the past granted an exemption to a married couple that collectively only had a 50% ownership interest as community property to a rent-controlled property, the decision would clearly have been in error under well-settled California community property law. There is no legal principle that an administrative agency, once having misapplied the law, is bound to continue making the same mistake forever. The law, in fact, is resoundingly to the contrary. When Santa Monica voters enacted the rent control law, they limited owner occupancy exemptions to landlords who individually had at least a 50% ownership interest. Because California statutory and case law hold that neither Mr. nor Mrs. Ziegenhorn do so in this case, staff recommends that the board affirm the agency's dismissal of their application.
Thank you. We have a few speakers in the queue, and I am pulling up the names of our speakers list. So our three speakers in the queue this evening are Ms. Sarah Ziegenhorn, Mr. Jim Kennedy, and Ms. Elizabeth Hansel. They will be speaking in that order. For the benefit of the public and also for our speakers, when we introduce you and promote you from attendees to be able to speak, there will be an approximately 30-second delay for the connection. But bear with us, we'll get through this together. And I am now going to invite Ms. Sarah Ziegenhorn to speak with us for 5 minutes as the applicant. Okay, Ms. Ziegenhorn, I am going to, it looks like you've unmuted yourself. You have 5 minutes. Our secretary, Mr. Gwynn, will be providing you with the time. You can start now.
Thank you. Let me begin by saying that I hope everyone is doing as well as possible during this quarantine. On behalf of my husband and myself, we want to thank the board for hearing our appeal under these circumstances. Our intention is that through this discussion, we can come to a sensible solution to guide us moving forward in resolving the last remaining issue on our application. We previously submitted written comments in response to staff reports under our reason for appeal and written response to the staff recommendation. We believe your staff is correct in pointing out the question before us. How much of an ownership interest in the property do each of the natural persons who form a marriage have? Eligibility requirement number 2 on the application reads, you must own at least 50% interest in the property as natural persons, as the date of the application for exemption is filed. The plural of natural persons implies that a married couple could potentially be eligible with 50% interest in the property together. A property acquired by the joint efforts of the husband and wife, community property that is held in common, allowing the couple to continue to act jointly to further their efforts. Our assertion is that the owner occupancy exemption process did not intend to divide and deny all married couples who own as community property less than 100% of 3 or fewer unit building. Your staff cites 3 case laws that show that a court, under certain contentious situations, can split in half the married couple's ownership of community property in order to take decisive action to protect the property of one spouse's undivided interest against another person's actions. However, as an administrative body, why would the Rent Control Board ever need to split a married couple jointly acting in harmony? The first case cited by your staff of a spouse depositing community property into a bank account in his name as a trustee for a third party is a wrong comparison. Firstly, this case is only triggered during probate because the other spouse died. Secondly, and most importantly, there is only a probate issue because there was a person with property interests outside the marriage who has a stake in the community property. This case is out of context to our simple case of 2 married people owning half of one property. Your staff had no reply regarding this legal case after we pointed out how it is not relevant. Instead, your staff came up with 2 more legal cases, which are California Family Code Section 11101A. It is a great example of when a court, and only a court, is asked to step in by one spouse who has standing against other spouse who is harming the plaintiff's spouse with a breach of fiduciary duty and is asking for an impairment of 1/2 interest in the community asset. Again, the owner-occupied exemption process is not a legal case. The Rent Control Board does not have standing to take action in court, and we are not suing each other for any wrongdoing. And Essex versus U.S. This is about taxes and a dispute with the IRS, so this is a major outside agent having a conflict with the ownership structure of community property. Another major difference was that the property in question was originally separate property that was gifted. So that played into the dividing equation. Plus, the IRS always gets its money, so the businessman at least got half his partnership tax protected when using his wife, but community property was not part of that protection. Again, the purpose of an underlying equal and undivided interest is to protect each spouse from the actions of the other spouse or an outside interest. That is not the situation with the owner exemption application process with natural persons who have community property. Courts only have to get down who has vested undivided interest when they have to split a married couple's ownership because of death, breach of fiduciary duty, outside claim, or other duress. Staff's case examples are when some serious financial repercussions hang in the balance that only can be resolved by separating individuals. But why does the city of Santa Monica have to act if an owner exemption case has to separate out a married couple? It is also disappointing that staff cannot find one married couple who owned less than 100% of their triplex duplex who applied for owner exemption. Their presumption is that if they did find a case in our favor, it would either be wrong or irrelevant. But a common sense approach would look at how other cases are handled, even if they are not cited case law. I would hope the board would want to know the approximate number of cases similar to ours since 1979 and what percentage were granted owner exemption. If these past cases were supportive of the staff's analysis that marriage does not matter, then a quick review of past cases would make the board's decision easier. Finally, we would ask for the board to either grant us owner exemption or suggest what would be an acceptable remedy. Thank you for your consideration of my remarks.
Thank you, Ms. Ziegenhorn. It looks like our other 2 speakers are also Mr. Jim Kennedy, and then after Mr. Kennedy, Ms. Elizabeth Hansel. So, Horn, it looks like our other 2 speakers are also Mr. Jim Kennedy, and then after Mr. Kennedy, Ms. Elizabeth Hansel. Okay. Sounds like we also might have a little bit of a delay. I think I'm caught up now. So I'm going to elevate Ms. Hansel. And you will have 3 minutes. Sorry, Mr. Kennedy. Technological growth happening before your eyes. Okay. Okay. Mr. Kennedy has joined us. I'm going to unmute you, Mr. Kennedy, and you will have 3 minutes. Mr. Kennedy, are you with us?
Yes, I believe I am. Can you hear me?
Yes. You can start now. Thank you.
Great. Hi, Jim Kennedy. I live in Santa Monica in a rent-controlled apartment with my wife, Elizabeth Hansel, who will be speaking next. And we are the brother and sister-in-law to Sarah and Will Ziegenhorn. So we were working together because we wanted to find a place in Santa Monica where we both could live. And we ended up finding this property, which was not in rent control until the owner had passed away on January 13th, 2018. It was in probate under the sister. And so we decided that it was a good deal because it was going to need a lot of renovation. Then we decided that through just our own decision making that Sarah and Will would live here and we would find another situation for us later on. The point is that there are two people living there who are owners. And that is the basis on which I think the intent of the Charter Amendment for the Rent Control Board in 1979. It seems that that situation is probably repeated several times over. And if the Rent Control Board wanted to better base on what they've done in the past, then a review of that material would probably make sense. And we're not sure why that hasn't been done. We didn't have access to that material, so we weren't able to do that ourselves. The last point is we understand that case law is important, but also the fundamental of what the law is about community property. And during the marriage, two natural persons have the property jointly and concurrently. That is shown to be the reason for community property. The division is only to protect each interest in a case of it needing to be protected by the courts. So that only before a separate property and after. So we really want to come to some reasonable conclusion, but with community property being what it is, and that it's owned by the Ziegenhorns, 50%, they're not able to, we're not sure how to concentrate the ownership into one person. So if we could have some guidance on that, that would also be helpful so that we could meet what the board needs, their criteria.
Thank you very much, Mr. Kennedy. We will be moving to our next speaker in the queue, who is Ms. Hansel. Ms. Hansel, I'm going to invite you now to participate, and you will have 3 minutes. Again, we have about a 30-second delay. Ms. Hansel, I'm not sure if you're having issues with connectivity, but you do need to accept in order to interact live.
Commissioner, we might have Mr. Kennedy move back up to the queues, and maybe we can question him. I had thought that they were going to be on the same computer.
I just received a chat from Ms. Hansel, and she says that she did not receive the notice. Please send to her again. Let me try to see if she's in the same room with Mr. Kennedy, and then she may be able to participate through his link. Okay. And for a public record, so everyone knows what I'm doing, I'm providing technical advice to Ms. Hansel about trying to access the request to participate.
We can withdraw the invitation and then re-invite her, Commissioner, and maybe that would work.
Okay. Okay. So let's see. I'm going to withdraw the invitation and attempt again. So yeah, and I'm not sure if Ms. Hansel has. We'll keep trying to help work through this. If Ms. Hansel is continuing to have difficulty, I'm not sure if her remarks are written, but one potential option would be to copy and paste them into the chat, and we can read them to the record. And yeah, because it looks like her request is still pending. So I just asked Ms. Hansel if
Oh, there we go.
Here we go. No. Okay. Nope. Looks like
she just disappeared entirely. She may have. Oh no, she's gone back in the.
Okay, I'm going to.
Let me try it, Nicole, and see if I have better luck. Just a second.
Okay. We now have two Elizabeth Hansons. Okay.
There, she's in the queue now.
Okay. Ms. Hanson, it looks like you have been successfully elevated. Thank you for bearing with us. You have 3 minutes.
Okay, great. Thanks for that. I've gotten very used to Zoom meetings over the last couple of weeks, and this is my first Blue Jeans, so a little bit of a different platform, but thank you. As Jim mentioned, we are trying to work out how we can get the family owner-occupied exemption here. And I just wanted to give you a sense of the type of action that we've taken to date with our tenants. We divided up kind of the conversation because of the time limits, but, you know, Sarah and Will live there at the unit and are seeing our neighbors on a fairly consistent basis. We've been checking in over the last really since the Stay in Shelter started here in Los Angeles, with our tenants, and you have their names, but who are right there, make sure that they're doing okay on rent, that it's not burdensome to them. Thankfully, at this time, they've all let us know that they are doing well in their careers, that they're not impacted. However, we had an interesting request from one of our tenants. She's a nurse here in Santa Monica, and she's actually headed to New York to go support the pandemic response there in New York. And she asked us if we would grant her a rent reduction for May because she's going to be in New York for the entire time. It's really likely not from our perspective as we look at it, it's likely not a pay hardship, but it was something that we wanted to support her in. And we did just a forgiveness of 20%, a little over 20% of reduction for her rent on May.
I'm sorry to interrupt, excuse me. In order to make sure that we have a clean record, it would be best for the speakers to confine their remarks to the availability or not under the law of the exemption, not extraneous things. Sorry for the interruption.
Yeah, no problem. Thank you. So just in seeking the exemption, as Jim mentioned, the triplex has been out of rent control until we purchased it is when it came into rent control. The rents are extremely reasonable and under market and have been even while it was out of rent control in the sense of the owner, Patty, she was taking care of all of the tenants, and we anticipate doing the same. So that's it. We'd love to come to a resolution and find out from you all what we need to do and hope that you approve our application. Thank you.
Thank you. I don't see anyone in the queue, so I'll take a stab at this first. I think this is a tricky case, and I am a little perplexed as to kind of this apparent idiosyncrasy in our law. I'm also a little perplexed, as we know that married couples as joint tenants are entitled to 100% of each other's respective interests, and I understand that there are cases that are in our staff report that indicate, there are certain circumstances where we look at 50% of the interest, such as when there's adversity between the respective partners in a marriage. But I am troubled by the fact that that doesn't seem to apply here. So I'm open to hearing from what my fellow commissioners have to say. Okay, so it looks like we have Commissioner Foster and then Commissioner Torosis in the queue. So Commissioner Foster, you're next.
Thank you. And I think it's almost helpful sometimes that it does not, that being elected to this position does not require one to be an attorney. Sometimes it helps me not cloud my analysis with that broad of a body of knowledge. I consulted with staff on this case on my own time and read over it a few times because it struck me as odd as well. I'm a married person and I understand how things are treated in my properties, but I always come back to the same thing. Our charter was passed by the people. It says what it says. It has certain requirements. Staff helps me interpret those requirements as it applies to an individual case. And the charter instructs me as an elected commissioner to preserve tenancies under its direction. And I, for one, am not prepared to manipulate and find a way to help investment partners decontrol tenancies. anything about these people. It doesn't. I'm sure they're fine individuals, but I'm not here to allow an investment scenario to decontrol a property. So I am comfortable with staff's analysis and my own research into this, and that's how I'm prepared to vote at this time. Thank you.
Our next speaker is Commissioner Tarosis.
Hi, thanks. Obviously, you know, I don't want married couples to be treated inequitably in these situations. It does strike me odd that community property where you have a married couple, just, you know, I'm in a marriage as well, and the fact that I would buy a property and not be able to avail myself of the same protections that single people would have, it's a little weird to me. I guess I have a couple of questions then for council. Do we always deny owner occupancy exemptions on all community properties that we've encountered?
I can answer this question. No, and there is no issue here of married couples being treated differently than single persons. If in this case, the couple who's applying owns 50% of the property, and then there's another couple who owns another 50% of the property. So there are four people with four individuals with an ownership interest. If these were four single people, very clearly, there would not be eligibility.
Okay.
Also, under California community property law, each part of the marital community owns an equal share of the community property. In the case of a married couple that owns 50%, they each own an equal share of that 50%, i.e. they each own 25%. The cases that Mr. Mordezai discussed don't talk about what is the dissolution and what is the division of the property after death, after marriage, or in a tax consequence exclusively. All of those cases start out with asking, what was the person's share of the property during the existence of the marriage? The issue came up in some of those cases when the marriage was over because somebody had died or there had been dissolution. But the question was, what was the ownership interest during the existence of the marriage? Both statutory law in California and case law says that the members of a marital community have an equal share. In the case of people who own, and in fact, Mr. Mordezai's report quoted the court specifically explaining that and saying, when a couple owns 50% of something, because the couple has an equal the individuals in that couple own an equal share, each owns 1/4 of that property. Yes, I'm sorry.
Sorry. Yeah, no, I understand that. And I'm sorry, I'm having an internet issue where my router keeps going out, so I actually missed like almost all of the staff report. I'm only speaking off of the reading that I read here, and I did take notes, you can see. I was not clear in what I read and even in the appeal. So you are saying to me right now that the Ziegenhorns only own 50% of this entire property. Okay, thank you. That's very helpful, and I didn't understand that when I read this. So I agree with Commissioner Foster then. This is clearly an investment scheme where four people have invested to decontrol a property. You know, maybe they all want to live there, and that's great, but that's not the intent of our law. And I have concerns. So thank you for clarifying that. I know that there was an ask of what's an acceptable remedy. I would assume that should they want to avail themselves of the owner occupancy exemption, they would have to transfer title such that one person or one couple would own it in whole. So thank you, and maybe they should have consulted with legal counsel before they purchased the property so that they could avoid this issue. Appreciate that.
All right, our next speakers in the queue are Steve Duran and Naomi Sultan. Commissioner Duran.
Thank you, Chair Phyllis. I don't know if there's an investment scheme or not, but I don't think the analysis needs to even go there. If you look at what the charter requires, and this is kind of what I'm focusing my position on, it says that it has to be a natural person. And what I found illuminating was when I read the supplemental brief by the Ziegelhorns, not once in the supplemental brief, after reading what staff had written in its brief, did they call themselves a natural person. I mean, it's absurd to do that because there's two of them. What they've called themselves was one legal entity. And the statute doesn't allow for one legal entity to get this benefit. And they say that the intent of the city charter was to prevent a couple other things, and then they add legal entities that may have various owners from qualifying for owner exemption. So I think the whole thing focuses on whether they're an individual or not. And as the legal entity of a married couple, they don't qualify as an individual. Later in their argument, they do raise the option of, well, if one of them were to pass, then the survivor would get all of the community property interest, and at that point, that individual would have the 50% requirement to apply for the exemption. But I mean, clearly that's not the case here. So the other point I want to make is, we, the board, must, as you all know, follow the law. And my understanding is the law is written to state individual. It's not written to include married couples, community property interests, and it's a different discussion to say whether maybe it should or maybe it shouldn't. Right now, today, it does not, is my understanding. So just based on that, and the admission that they call themselves a legal entity and not an individual, I feel, at least it's my position, that the dismissal was appropriate under these facts, and I feel that we should affirm what the decision was earlier. Thank you.
Thank you, Commissioner Duran. So I see Commissioner Sultan has removed herself from the queue. I just have a quick, I want to kind of frame my objection to this issue, and then I know that Commissioner Trosis has a follow-up question. So it's my understanding that if we were to treat this married couple as one person, right, like the Ziegenhorn unit, that their ownership of 50%, if there were one person and their residence on the property would be sufficient to establish an owner occupancy exemption. Is that correct, Council?
If there were one person, one individual human being who owned 50%, yes, they would qualify. That one individual human being would qualify.
Okay, so here's my pitch, and here's where I think I'm coming down on the opposite side of my co-commissioners, and that's the marital unit is to be treated as one unit, and when members of a marriage purchase property together as joint tenants, which it appears that they did, each joint tenant is entitled to 100% of the ownership interest, right? They have right to control 100% of the ownership interest. There's no adversity such as if there was a breach of fiduciary duty between the members of the marriage. And I think that we should not be construing our law to basically preclude married couples who own property, 50% interests in property, where each married member of the marriage, has 100% claim to 50% interest in that property, to be ineligible merely because the marital unit is not a natural person. I think that that's a perversion of our charter and an inequitable result. And I don't think, I don't know how to turn that off. But so that's kind of where I'm coming down. But I see that I am in the minority, so definitely the minority so far, and open to hearing from my fellow commissioners. Looks like Commissioner Torosis has a question. You're on mute.
Okay. Yeah. Mm-hmm. So I clearly totally missed the mark when I was reading the staff report, and now having gotten here and gotten my questions clarified, I'm thinking about it in a new light. So thank you. I want to ask very directly, which is what I think Commissioner Phillips was getting at. Mr. Lewis, if only one of the Ziegenhorns was on title to this property, one of the Ziegenhorns, not both of them, as community property, would we have granted this owner occupancy exemption?
Yes, absolutely.
That's what I thought. Okay, now that I've gotten clear on what the situation is here. So to me, I'm a little concerned. I think like strictly reading the charter, we have to interpret the law that we have. And we have to probably grant this owner occupancy exemption, but I'm very concerned when we ask about like what's the remedy here, and Commissioner Foster is giving me a disgusted look. It sounds like the remedy would be, again, to re-record, the deed on the property, or us to change our charter, as a matter of policy. If we think that, I would want to know why we wrote it the way we wrote it back in the 70s. First of all, what was the intent behind that? But then secondarily, it is what it is, and we have to apply it. And I don't know that this makes a lot of sense, treating the marital unit differently than an individual person. But, I'm inclined to agree with the staff report, but this is something that doesn't sit right with me.
I do want to just add one point, which is we do recognize non-natural persons in owning or being eligible for owner occupancy exemption, such as when things are held in trust and they have to own a certain percentage of the trust. And then if they own that percentage and the trust owns, more than 50% of the property, they get it. I mean, why are we treating marital units different than a trust?
May I answer the question?
Mm-hmm.
We don't, is the short answer. It is true that if somebody owns if somebody holds title as a revocable trust, because the courts have told us that that is purely an estate planning device, and the person continues to have their own actual individual interest in that property, and that it's treated as a separate entity only for estate planning purposes, we are, for all other purposes, to treat that ownership as an individual ownership. So we would look at this the same way. If there was a couple who, as a couple, had a revocable living trust where their interest as a couple was in 50% interest, or it was just the trust itself that owned a 50% interest, our recommendation would be the same. We still are just looking at, is there an individual who has at least a 50% ownership interest? I would say also, it's worth bearing in mind the case that we recently had in the Court of Appeal, 1041 20th Street versus Santa Monica Rent Control Board, in which the court, in that case, the board prevailed, but what we prevailed on was the principle that we must do exactly what the charter says, and we have no authority to do other than what the charter says. The charter specifically refers to an individual with at least a 50% ownership interest. California law clarifies that the marital interest the individual's interest in marital property is a 50% ownership interest in what the marital community owns. So under California law, when under both statutory and case law, if a marital community owns 50%, each member of that marital community owns a 25% interest. Our charter requires an individual to qualify for the exemption to have a 50% ownership interest. So it does not appear that there is any way, without either consistent with what the charter's demand is, to grant this ownership owner occupancy exemption. Which isn't to say that there aren't ways that the couple could do that, but right now there is no individual with at least a 50% ownership interest, and we would be treating this no differently if it were held in some other form.
Thank you. I saw that Commissioner Foster. Oh, sorry. Commissioner Foster, looks like Commissioner Sultan has raised her hand and she hasn't had the opportunity to speak yet. Commissioner Sultan? But you're on mute. Wait.
All right, thank
Okay.
you, Phyllis. Yeah, I mean, it appears to me that our hands are tied by the charter and by California law. So as much as I would like to be able to, in my personal opinion, should this married couple have the same rights as like an individual, in terms of if they own 50% of the property, like, yeah, I would say, yeah, that makes sense. But I think our quibble is with the law. And so what we would need to do is potentially change the law as opposed to, as Mr. Lewis says, like, we're not permitted to deviate from the charter. So unfortunately, I think that the result that we must reach is that this couple doesn't qualify for the exemption at this time, given the way their, ownership interest is currently configured.
Thank you, Commissioner Sultan. Commissioner Foster, I see the writing on the wall. So if someone wants to make a motion.
I'll make a comment and I'll make a motion. Yeah, my comments earlier were just flipped and maybe a little terse. Naomi Sultan summed it up exactly like I would like to say it. The way the law is written today, I'm not saying it's not confusing or potentially conflicting, the way it's written, but that's the way it's written. And so just like we hold every other ownership pair who hasn't proved, their number of days or what have you, we have to hold everybody to the same standard and not what we wish it was. So I'm going to move that we accept the staff's, that we affirm the dismissal recommended by staff.
I'll second that.
Okay. Can we have a roll call vote, please?
Commissioner Duran,
Yes.
Commissioner Foster,
Yes.
Commissioner Trosis,
Yes.
Commissioner Sultan,
Yes.
and Chair Phyllis.
No.
Motion carries.
Okay. Next item, as I toggle back to our agenda, is administrative item 12A, which is the annual report. May we have a staff report, please?
Hi. Good evening, chairs and commissioners. My name is Morena Zelaya. I'm an information coordinator with Rent Control, and I'll be presenting a brief overview of the 2019 annual report. Let me just pull it up. So I'll try to be thorough with the slides in case there are any attendees participating by phone. 2019 was the 40th anniversary of Rent Control in Santa Monica, and this report tries to condense all the work that the agency undertook during that significant year. This presentation will show some of the highlights of the report, and I encourage the public to read the report for more information and details. The report is broken into 4 parts: status of controlled rental housing, impact of market rate vacancy increase, impact of the Ellis Act, and departmental overviews. Rent-controlled housing accounts for slightly more than 1/2 of all housing in Santa Monica and just over 2/3 of multifamily housing. This amounts to 27,381 units subject to rent control. This is a net loss of 64 units compared to 2018. And 2019 had the second lowest number of controlled units in the last 10 years. The majority of these units are 1 and 2 bedroom units. And combined, these make up 79% of units. There's a typo in the report, and it says that it's 82%, but it's actually 79%. So the map on the left shows the distribution of controlled units throughout the city, and as you can see, it's fairly evenly distributed, though Area C of the city, which is downtown, has a pretty low percentage, and Area G, which has a lot of smaller buildings, has a pretty high percentage. And there's a new figure in the annual report this year that's not in the presentation, but it shows how property densities or the property sizes vary throughout the city, and it gives a good idea of the density of the neighborhoods. So the agency breaks down controlled units into 5 categories: market rate, long-term, housing choice, also known as Section 8, restricted units, and zero MAR units. And this year, the number of restricted units actually went up by 5 from 2018. And these units can be restricted for a variety of reasons, including owner-occupied eviction, Ellis Act restrictions, or they had their rents restricted due to code violations. Zero MAR units only went up by 1 this year, and that unit may have previously been an owner-occupied unit. But in good news, the number of Section 8 units has actually remained stable from the previous year. It didn't change. And there's also a good chance that it might be higher if any landlords haven't applied for a fee waiver for their Section 8 tenants. But there's been no change from year to year, so that's good. And then as you can see from the pie chart on the left, market rate units make up 72% of all controlled units in Santa Monica. And the number of units that became market rate this year is far fewer than the number of units that had become market rate in 2018. There was 500 and something versus 139 this year. So fewer units became market rate this year. So the median initial rents by unit size continue to rise every year. It's slowed for units larger than studios, and 2 bedrooms have remained flat. As you can see on the chart at the bottom, 2018 was 3,200 and 2019 was 3,200. So that stayed flat, but these numbers could always change if we get late tenancy registrations. So there's always the caveat for that. The studio sizes did keep their trend of increasing by $100, $1,750 in 2017, $1,850 in 2018, and $1,950 in 2019. The income needed to afford a unit in Santa Monica keeps going higher. Rate of the increase, the market continues to just cater to people of very wealthy incomes. You need basically double the income to afford a market rate unit in Santa Monica versus a unit without vacancy decontrol. No household earning the area median income for LA, which is $73,100, could afford even a studio in Santa Monica. And even though Santa Monica has a higher household median local income, if a household within Santa Monica needed to move, the price of initial rents is so high that they would probably be priced out of the community. So, every year more and more, it just becomes harder and harder for people to move into Santa Monica or to even stay in Santa Monica. The charts at the bottom show how affordability is distributed amongst the affordability levels for incomes in Santa Monica. Units affordable to extremely low incomes are off the chart because there's actually only 6 market rate units in the city that are affordable to those incomes compared to 1,817 prior to decontrol. So you don't even see the option for extremely low at the bottom chart because it's so tiny. So the next area that we'll be covering is the Ellis Act and withdrawals conducted within the city. Obviously, Ellis activity continues its rapid pace in 2019. It's a very hot topic, and landlords definitely use it to, get out from under rent control regulations and try to redevelop and construct new properties in order to try to get the maximum dollar out of the properties that they're purchasing. In 2019, 26 properties with 92 units received notices of intent to withdraw, and 13 of these properties with 44 units completed the process. And then from 2018, 13 properties with 70 units that started the process then actually completed it in 2019. So of the 656 units ever withdrawn from the rental market, 473 properties are still currently withdrawn. And you can see that in the bottom chart there. And that's accounting for properties that are controlled after they've been redeveloped and re-rented. And then in 2019, also, unfortunately, we saw fewer units coming back as re-rentals. There were only 20 this year. And so this amounted to a net loss of 94 units in the year. As you can see from the maps, Ellis Act withdrawals happen throughout the city. They can impact basically anywhere. Obviously, in areas where there are more controlled properties, it's going to happen a bit more, but it's a fairly even distribution. The highest shares can be found in areas E and G of the city, which are mostly made up of buildings with 10 or fewer units. And if people are wondering what I'm talking about when I mention these city areas by letters, there's actually multiple maps in the annual report where you can see the city divided up into different letter areas. So you can reference back to that. And then we see that in area C of the city, there is a high share of units ever withdrawn, but it's got the lowest share of units ever returned. And that's our downtown area of the city, and that's where we're getting more of those new properties being built. The post-Ellis use of buildings is pretty geared towards continuing to have them be in a residential use. As you can see from this pie chart, most of them are in apartments or mixed-use apartments, condos, single-family dwellings. There are some that are being occupied by family occupancy, and then about 2% non-rental residential, or maybe some friends are all living together or something like that. The most popular use post-Ellis for our property is to demolish and build condominiums or single-family dwellings. That's about 47%.
Can I ask a question about this specific slide? Thank you so much. This is very helpful. The post-Ellis use, how are we getting that information? And then also, can we tell what percentage or how long are they staying off the market under Ellis before they're being returned? Is it very close to the 5-year period? Is it not? Can we tell how long something's off the market before, or off utilization before it's returned in that regard, especially if residential is the most popular use?
So we actually have to sign off on demo permits in our office. So we get a lot of the information about what the properties are being used for. So we find out, and we, I believe Tracy actually receives a notice whenever there's a demo permit pulled on a property. So we can track when they're applying for these permits, and then we can also track when the permits are finalized. And so that's how we know, and on the permits they have to say what it is that they're intending to do with the property. So that's how we know sort of what the intent is, and then how long, you know, when the permits were pulled and when it's finalized, and so how much time has sort of elapsed for when the property was Ellis to when it was brought back into use.
Okay. I would love further information, just as a follow-up on the post-Ellis activity. I understand that we get the permits, but then I guess my question was more like, how do we know that it turned into a parking lot? How do we know that it turned into a vacant lot if nothing's happening there? What if the permit expires? I know I'm getting into way too detailed questions for this, so that's totally fine. We can address this in a separate meeting, but this is very interesting, so thanks for this slide.
If I could just chime in on this. This is Tracy. Yes, as Marina was saying, we put time into researching what happens with these properties. So partially it comes to us through the permits that we sign off on, whether those are demolition permits or building permits that come through our office. We also do research on a regular basis, looking for information about properties, what's happened with them. We may send an inspector out to take a look at the property. We do a number of things. So we're constantly updating this information during the course of the year. Other city departments issue permits like a reoccupancy permit for a property that's been withdrawn, and we get that information. If it's going to be an existing building is going to be reused for something like family occupancy or non-rental, we will see that information item when it's provided to the council. As to your question about how long properties stay off the market, you'll see on page 28 of the written report, for the 5 properties that were returned to rental during 2019, one of them had been withdrawn as early as 1986 and just returned in 2019. Another had been withdrawn in 1990. And then there was also a property that was with the most recent of this year's returns was withdrawn in 2014. So they kind of cross the gambit. It may be that the property from 86 was recently resold and the new purchaser goes to re-rent it. So there's a variety of different situations that result in a property coming back into the rental market. So if you'd like additional information, we can pull that together as well. But part of the project that Marina and another information analyst work on is tracking the use of these properties.
Okay. That's really helpful. Thank you. Sorry to take up time.
That's quite all right. That's what we're hoping to do.
Yeah, thank you. Thank you, Tracy. Okay, so now I'm going to give some departmental overviews about staff activity in 2019. As you can see, community members continue to seek out staff assistance from the Public Information Department in high numbers. We had 15,176 public contacts in 2019, and this includes people coming in the counter, people calling on the phone, and email correspondence. So people are still actively seeking out information from us directly. We also had 133,623 total website hits in 2019 with 38,413 unique website visitors. This is down from the previous year, but that's probably due to people becoming familiar with the online tenancy registration portal that we introduced. And so as people become more familiar with it, they obviously don't need to go back and, fix whatever errors they've made or try to find more information about how to use that portal. The public information staff also conducted 9 community meetings or seminars throughout the city. So we hosted meetings with other city departments. We went to various tenant buildings to speak to tenants directly as a group about, concerns that they had with a building being sold, potential new landlords, concerns about construction, Ellis, things like that. So we still had lots of interaction within the community itself and not just people coming out to see us at City Hall. So the hearings department had a busy year. They did have 17 fewer decreased petitions filed in 2019 than in 2018, but a higher percentage of them were successfully mediated. This is an increase from 56% versus 37% in 2018, which I know had been a point of concern for the board last year, where it was encouraged that we try to mediate these. So we've moved our mediation percentages up. Most excess rent complaints continue to be successfully mediated, and though there were fewer construction petitions filed this year, or in 2019, I'm sorry, the ones that were filed were spread out across a greater number of properties. So we had more properties with maybe one or two petitioners versus the previous year when we had one large property with 26 petitions, I believe it was. And then one part of the legal department's many duties includes tracking buyout agreements. So buyout agreements are required to be registered with the city. And of those filings that we received in 2019, we actually saw that the average buyout amount dropped significantly from 2018, from 54,611 to 40,807. We saw big decreases in areas F and B, and those could be accounted for some pretty significant one-off buyouts that happened in 2018 in a few properties. So that may have skewed the numbers for 2018. So the drop may not have been as high for the overall average if we had taken those out, but it is a pretty significant drop this year. Even with the drop, buyouts still tend to be higher than the relocation amounts mandated by the city. This is taking into account the increased relocation that the city ordered back in February of 2019. And with that, that's a relatively brief overview, but if anyone would like more information, the report will be available on our website and can be picked up from the Rent Control Office once City Hall opens to the public again. And I'm happy to take any questions.
Sorry. I'm like trying to figure this thing out. Okay. We have a request to speak from Commissioner Foster. No. Okay. No request to speak.
The report. It was a comprehensive report. It always is. This is must-read material. As always, staff did an amazing job. I don't have any questions.
Great. Okay. Well, thank you, Miss Zelaya. You've done
Tracy might.
Oh, I thought you were waving goodbye. Okay. All right. Tracy, you're on mute.
Tracy.
Thank you. I want to thank Marina for her hard work on this report. This is the first year that she's undertaken this endeavor. Did an excellent job. This is a big project, as you can see, summarizing all of the work that goes on in the agency. So a number of people contribute to the effort, but Marina pulled it all together. So I really want to thank her for doing that. And then I would just ask the board to make a motion or direct us to forward this to the City Council to meet the charter requirement of reporting on the current status of the controlled housing stock on an annual basis.
Okay, I also move, Chair Phyllis.
Okay, Commissioner Duran, and I will second it. So we have a motion and a second. Can we have a roll call vote? Oh, Lonnie, I think you're on mute. Okay. Okay, looks like Lonnie may have stepped away, so I will just go through the roll call vote. Commissioner Sultan.
Yes.
Commissioner Foster.
Yes.
Commissioner Trosis.
Yes, great job.
Commissioner Duran.
Yes.
Commissioner Phyllis. Yes. Okay, great. Excellent.
All right, thank you.
Thank you. Okay, let me toggle back now. So much toggling. Next item on the agenda is the mid-year budget report for fiscal year 2019-2020. Commissioner Trosis is back just in time. May we have a staff report, please?
Yes, really the written report is quite detailed. I'm going to give you the Cliff Notes version. This updates the board. It's just an information item. No action is necessary tonight. It explains the board's financial experience through December of 2019. At mid-year, revenue collected was higher than the total amount we had projected for the fiscal year by about $83,000. That was due primarily to payment of 2 outstanding judgments on registration fee collections. The expenditures for most line items at mid-year were in line with our projections, with a few line items reflecting over expenditures and a few showing savings. Currently, it appears that at year end, our expenses may exceed those budgeted by about $50,000, most of which is attributable to non-recurring costs related to our capital improvement project to develop and implement the new database and information system and integrate it with our document management system. So the bottom line is, given the increase in revenue and even with the increase in expenditures, it looks like net revenue at the end of the fiscal year will be approximately $124,000 instead of the $42,000 that was originally anticipated when the board approved what was essentially a balanced budget. Any savings that we have will be placed into the board's cash reserves, which cover the board's liabilities for earned but unused vacation and sick time for agency employees, and is the agency's safety net in case of an emergency. So as I said, the details are in the report, but I'm happy to answer any questions that you have.
Great. Oh, Commissioner Gerosis, you have a question. But you're on mute. You're on mute.
Sorry, I'm here. So I saw that we collected a lot of outstanding registration fees in FY 1920, but then it appears as though in this year we're not collecting as many back registration fees. Is there any reason for that, or it's just that we're getting caught up?
That's it. We're getting caught up. Mr. Mordesai, along with others in the agency, have been working very hard on this project for the past few years, and we have very few accounts which now have outstanding balances. So we do not anticipate continuing to collect a high level of unpaid registration fees in future years.
Okay, thank you, and thank you, Mr. Mordesai, for all of your hard work on that. I think it's super critical. I thank you for doing this, Tracy. I think I'm, like many of my colleagues, are very concerned in light of COVID and in light of the potential economic ramifications for our agency, both direct and indirect. And so I don't know if it's appropriate for a closed session, but I would love to hear kind of a plan in light of the current economic situation and any sort of plan B, plan C contingency plans should we see a decrease in revenue coming into the agency, and how we plan to mitigate any negative impacts of that. And I would just ask for that kind of report back while we're able to be proactive about it.
Yes, well, we will be working on preparing the board's budget for the next fiscal year. We generally present that at the beginning or at the May meeting, So we will have an intervening meeting on 2 weeks from tonight, where we're going to hear the appeals that we weren't able to hear for the meeting that was canceled. But we will be bringing a budget to you on the May 14th meeting, and we will be addressing the issues that you've raised.
Okay. In light of that, I'm ready to approve. I know this is information, so we're not doing any voting, but I'm good with this, and thank you.
Okay, thank you.
Great. I know that we're super grateful for all of the hard work and the financial responsibility and accountability of our agency, and I think it's important to keep the trains running even during times of crisis. So thank you for all your hard work. That brings us to the conclusion of the meeting. I will entertain a motion to adjourn.
So moved.
I'll move. I'll second.
Okay, we have a motion by Commissioner Foster and a second by Commissioner Duran. I almost lost the screen. Okay. May we have a roll call vote, please? Okay, Lonnie, looks like you may not be with us, so I'll just take it away again. Commissioner Duran.
Yes.
Commissioner Tarosis.
Yes.
Commissioner Foster.
Yes.
Commissioner Sultan.
Yes.
And Commissioner Phyllis. Yes. Okay, motion carries. Congratulations for a successful meeting. Looking forward to seeing everyone again in a few weeks. Thank you for everything that we're all doing for the community. Encourage our community members who are listening or watching to reach out to us if you have questions or concerns. Everyone stay safe, be healthy, and looking forward to hearing from everyone again in about 2 weeks. Thanks.
Thank you guys. Bye.
Bye-bye.